Hello, I'm David Schraga, Secretary of the Beverly Hills Bar Association's Entertainment Law Section, and thank you for being with us today. I'd like to begin by acknowledging our sponsor, Lawyers Mutual Insurance Company, whose support of the Entertainment Law Section helps make these excellent CLE programs possible. For 5 decades, Lawyers Mutual has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that LMIC is directed by a group of dedicated lawyers. Learn more about them at lawyersmutual.com. And having come to know these folks myself through the entertainment law section, I can say without reservation that they are great people, true experts, and a real asset to have in your corner. I'm delighted to now introduce our speakers for today's seminar, Irene Lee, Paul Boast, and Amy Lucas. Irene is a partner at Russ, August, and Cabot, where she focuses her practice on all aspects of intellectual property, including patent, trademark, copyright, trade secret, and the right of publicity, representing clients across a wide range of industries worldwide. A registered patent attorney fluent in Korean, she has been recognized as a super lawyer for over a decade, named to the best lawyers in America, and featured on Billboard's top music lawyers list and Variety's 2025 Music Legal Elite list, among numerous other honors. Just 3 weeks ago, she got a jury verdict in her client's favor against Ye, formerly known as Kanye, in music copyright trials here in the Central District of California. Paul Boast is an attorney in Shepard's Intellectual Property Practice Group in the firm's Century City office. Paul is a holistic trademark and copyright practitioner, representing his clients in all stages of federal court, pre-litigation and litigation, and before the Trademark Trial and Appeal Board. Additionally, Paul manages trademark portfolios, clearance, and prosecution for clients in a variety of industries. And our third speaker is Amy Lucas, a litigator and trial lawyer at O'Melveny and Myers, whose practice spans copyright, trademark, right of publicity, First Amendment, contract, and other commercial disputes, as well as mass tort and product liability matters, class actions, and emerging risks involving generative AI and intellectual property. She's represented some of the world's most influential companies and high-profile individuals across the entertainment, new media, music, sports technology, fashion, pharmaceutical, and consumer product sectors, earning recognition for high-stakes courtroom victories exceeding $50 billion with a B. Amy also mentions an active pro bono practice representing clients in federal and state criminal trials, civil IP litigation, and civil rights appeals throughout the U.S. Supreme Court. Just an extraordinary panel of experts today, and we're really fortunate to have them with us. And now, let's get started.
Hey everyone, I'm going to share my screen now. Let's see if I can successfully do that. Can you see that?
Yep, we can see it.
Wonderful. Okay, well, again, thanks so much, David, for the kind introduction. And very pleased to be here with Irene and Amy to discuss what has been titled Trademark Yourself, the Lanham Act and Likeness Protection in the Entertainment Industry. This was precipitated by the registrations that Matthew McConaughey has gotten recently related to his identity and some of the trademark applications Taylor Swift has filed, excuse me, for sound marks for her voice, uttering certain phrases. But we thought we'd start at the beginning with just general Lanham Act protection of celebrity assets. So celebrities and their right holders can register aspects of a celebrity's identity that serve as trademarks under the Lanham Act. And these are registrations on the principal or the supplemental register of the Patent and Trademark Office. I've identified here some registrations owned by 56 Hope Road Music Limited, which is a company formed by the children of Bob Marley, or at least 8 of the 14 children, that own certain assets in Bob Marley's identity. So they own standard character word marks for Bob Marley's name. Here are a few of them, Bob Marley and Marley. There are many others for a wide variety of goods and services. The family has also registered design marks that include Bob Marley's image. So you'll see on the left there, there's a registration for Bob Marley, a tribute to freedom, which includes an image, a depiction of Bob Marley. And I believe that's for a restaurant. And then on the right is an image that you may be familiar with, particularly if you're interested in Bob Marley's music or reggae music. This is the Tough Gong record label logo. And in the middle of the star there is a depiction of Bob Marley. I don't believe the Marley family has done this, but I know other celebrities or their rights holders have registered signatures. So that's yet another example of identity being registered with the trademark office. Um, a celebrity, though, cannot register, at least not now, notwithstanding McConaughey and Swift's applications, as we'll see later, their entire identity or persona with the U.S. Patent and Trademark Office. So the question is, does a celebrity have recourse under the Lanham Act when aspects of her identity are used without her permission? And to this, we'll turn to another case relating to Bob Marley, 56 Hope Road Music Limited v. Avale. The short answer, though, is yes. In the Ninth Circuit and other circuits, celebrities have long asserted trademark-like rights in their personas and identities, and they've obtained relief for use of the same that is likely to cause confusion. And of course, that's a key component when we're talking about protection under the Lanham Act, is it has to be use that is likely to cause confusion. This is commonly thought of or considered a false endorsement claim, although we'll see in 56 Hope Road Music Limited that endorsement is a little bit of a misnomer. By the way, before I move on, I wanted to just quickly note that this is, even though I'm kind of monopolizing things right now, this is a discussion today. I think we termed it a discussion. So I obviously, Amy and Irene know that they're more than welcome to just butt in as they like. And as attendees, if you have questions, please just include them in the chat and we'll either address them as they come along or address them at the end. Yeah, I want to make that abundantly clear.
Oh yeah, I think you're doing great. We're just setting the table.
Wonderful. Thank you. Thank you. So there is a long line before this 56 Road Music Limited case where celebrities in the Ninth Circuit and other circuits have asserted trademark-like rights in their persona and in their identities. One of the famous cases was Tom Waits suing Frito-Lay for use of a sound-alike voice in a chip advertisement. There's also a case where Vanna White sued, I believe it was Samsung, for the use of a robotic Vanna White type figure in an advertisement. At issue in the 56 Road Music Limited case was the use of Bob Marley's image on apparel. Now, I will say this case is best known for establishing that there is no right to a jury trial on a claim for equitable disgorgement of profits under the Lanham Act, but we're not going to touch that today. We're going to talk about just the issues with respect to identity and persona. So again, 56 Hope Road is composed of Bob Marley's children, or 8 of them, and their purpose is to commercialize Bob Marley's interests. The defendant here, Avale, obtained copyrights. So they own copyrights in certain photographs of Bob Marley. They purchased them from a photographer named Roberto Raban. And then they licensed those photographs for the creation of apparel. And this apparel was sold in Walmart and Target. And the apparel itself, neither on the apparel, the front of the apparel, or on its tag, used any of 56 Hope Road's trademarks. Did not use the Bob Marley trademark. It did not use the Marley trademark. Any use of Bob Marley or Marley was purely in the description of the product. So if you went to Target to buy the product, it would say, Rastafarian shirt, and then deeper down to the description, it would say depicting Bob Marley or something to that effect. So 56 Hope Road sued Avale, and on summary judgment, the court ruled for Avale on its claim for infringement of the registered trademarks, holding that use of the trademarks in the description of the products was a nominative fair use. It also granted Avale's MSJ on 56 Hope Road's claim for a right of publicity violation under the Nevada right of publicity statute, because there's a statutory nuance in Nevada that if you know of an unauthorized use of a right of publicity and you don't register it within 6 months of that use, you lose your right of publicity. And 56 Oak Road thus had not timely registered its right of publicity. So it lost on its right of publicity claim as well. But the
And I
case,
think before you go on, Paul, I
yeah,
think this highlights for people what a lot of people who don't practice in this area may not know is that the right of publicity statutes, there's no federal right of publicity, there's no uniform right of publicity, there's like no restatement. So it's a 50 state patchwork of laws, and you have to do a lot of diligence in figuring out what the remedies are, what the elements are, what these procedural mechanisms are. So right of publicity can be a minefield for a lot of lawyers and celebrities who are interested in enforcing their rights.
yeah, that's precisely. I mean, anyone who's done this work has gone to Jennifer Rothman's website to look at each state's right of publicity uh, uh, statutes to determine, how they differ from state to state. And yeah, we'll get into that a bit later too, Amy, with respect to efforts to make a federal right of publicity. And to be clear, in this case, the Ninth Circuit, when it reviewed this issue, made a point of stating that they are not trying to enact a federal right of publicity by virtue of their holding in this case. But well taken. So the case went to trial on the 1125A claim that use of Bob Marley's image on the products itself constituted a false endorsement. And to be clear, 1125A is what people sue under when they're suing for, among other things, infringement of a unregistered trademark, a common law trademark, or in this case, something that's trademark-like, like a celebrity's identity or persona. Um, so at trial, the jury found that Avalay's use of Bob Marley's images on apparel violated 1125A of the Lanham Act. And the Ninth Circuit affirmed, albeit on pretty narrow grounds. So this is what the Ninth Circuit said in its opinion affirming the jury trial verdict. Defendants claim that the 25A claim fails as a matter of law because the celebrity's persona is too amorphous to constitute a name, symbol, or device under 1125A. And what's being quoted there is what really needs to serve as the trademark for a claim under 1125A. This premise is incorrect. Our jurisprudence recognizes an 1125A claim for misuse of a celebrity's persona. And then they quote the Waits case, a celebrity whose endorsement of a product is implied through the imitation of a distinctive attribute of the celebrity's identity has standing to sue for false endorsement under Section 43A of the Lanham Act. On appeal, defendants made a argument that, hey, there's no endorsement here. We didn't say Bob Marley endorses this product or his family endorses this product. There's no confusion as to endorsement. What we did was we used a picture of Bob Marley on the product. So there's no, it didn't fit in with the idea of, or the past precedent of cases where there's a voiceover or there's some imprimatur of endorsement that the celebrity is suing over. And in response to that, the Ninth Circuit said the plain text of the statute, that's 1125A, establishes that a viable false endorsement claim does not require that the mark be used in connection with separate goods or services to promote the purchase of those separate goods. It may be used directly on the defendant's goods. So this was again a point that for a false endorsement claim to be pled, it doesn't have to be endorsement per se. The endorsement can be the use on the goods themselves. By the way, this highlights some of the defenses that defendant did not really pursue at trial, that it tried to pursue on appeal that kind of spoke directly to this and may have been viable. I was involved in this lawsuit. I represented the plaintiff. It's dead and gone now, so it is what it is. But perhaps some of these defenses could have been meritorious. But I mean, the defendants on appeal tried to, for the first time, assert like an aesthetic functionality defense that their use of Bob Marley's image was aesthetically functional. They tried to assert a Daystar, defense, basically that they owned the copyrights in these images. So plaintiffs are usurping the copyright laws by making trademark claims. They tried to make a Rogers defense. Of course, Rogers and Grimaldi in 2015 was very different from Rogers Grimaldi now, but still tried to make a Rogers defense. And the court, or the Ninth Circuit, ruled that they had waived all those defenses. So perhaps the case would have come out differently had they timely made those defenses or asserted them. But be that as it may, this is a pretty narrow holding. But I think it does speak to the way that 1125A can be used to vindicate the rights of celebrities under the Lanham Act.
So, Paul, I appreciate
Yeah.
you bringing up the case because as a practitioners who were not involved in the case, we were watching the case, how it was playing out. One of the things that we found interesting was the defendant, despite the fact that they owned the copyright or licensed the right to use the copyright, and I understand that was not timely raised, that defense would not have worked under 1125. And one thing that we were looking at from the outsiders was whether or not the plaintiffs thought of asserting any of their own copyright or if they had any visual art copyright that they could have asserted. So I don't know if you can share any of those without getting into any privileged communications before you started initiating the lawsuit.
Yeah, that's a great question. We took over the lawsuit in the midst of discovery.
Mhm.
So I don't even have that information. But that's a really good question. I think the problem, of course, with asserting a copyright claim is we would have to identify images owned by our clients that are substantially similar to the images used by the defendant. And because these are not sort of these, I think the copyright interest in our images would be construed pretty narrowly because they're of a non-fictional subject. And of course, courts would be reluctant to find that any image of Bob Marley necessarily infringed um, or infringed the copyright in another image of him. Thus, we could monopolize our copyright interests. But a very good question. I imagine that I think what happened in this case too was that defendant purchased an entire portfolio of images done in one sitting of Bob Marley, and so we didn't have any other. I don't think our client owned any images from that particular photo shoot. So we didn't even have like even a thin claim of copyright infringement based on substantial similarity. But good
Yep.
question.
11 years later, we're learning new facts.
Yeah, yeah.
And
Um,
another
Well,
thing go ahead, Amy.
no, go ahead.
One of the things that we were watching as the case was coming down was we found this Ninth Circuit coming out and pretty much saying this is direct quote from the case. In celebrity cases, the court generally applies 8 factors. And you could see, and then Paul, if you go to the next slide. So these 8 factors pretty much track the sleek craft factors, but it was interesting from our point of view that the Ninth Circuit made a point to point out the first 3. Those are very bespoke to quote unquote celebrity cases. And because we do represent some of the folks who are kind of well recognized, the first 3 prongs are the ones that we usually focus our effort. The last 5, if you're in this space or if you're in marketing, those are identical to the last 5 of the sleek craft. But if you look at the first one, the level of recognition that the celebrity has among the segment. So it's not just the level of recognition. It's not just the fame, notoriety, but you have to look at the segment of the society for whom the defendant product is intended. So the one thing that I have is, so this is Otani shirt. And I think if you're in LA, I think most people know who he is. But if it's selling baseball cap, I think we can say, yes, that is the among the segment of the society for whom the defendant, the infringer who's selling baseball cap with Otani on it. But if you are kind of moving away from the athletes or apparel, like a chicken, I don't know, restaurant or like a coffee maker, I'm thinking if it's not related, and it may not necessarily trigger this. But I think the first factor seems to just equate to the strength of the mark. And if you go to the next slide, it takes you to the relatedness of the fame or success. So, Paul, if you go to the next one, it's the fame of the celebrity to the defendant's product. So now you're looking at what products are the defendants selling using the fame or success of the celebrity. And if you take me to the next one. So this is where the similarity of the likeness. So just staying on the example of Otani, if he's using his image, that's one thing. If you're using his name, that's one. Used by the defendant to the actual celebrity. But if you are just using, let's say, number 17, which is back number, is that sufficient? So these 8 factors, again, very fact-intensive analysis, similar to Sleekcraft. So if you are in this space and representing celebrities, or if you're in the marketing and thinking of using somebody pretty well known, I think these are the factors that you need to consider or tell your marketing teams to consider before adopting a marketing strategy.
Irene, that's exactly right. I just had this come up, this exact issue, not with Otani because that's your client, but with another very well-known sports figure. But it's they weren't using his name, they weren't using his face, but what the competitor was doing, was a competitor of my client who had exclusive endorsement rights. They were using his accomplishments. And so like after every single huge tournament win, the competitor would be putting up, social posts that were very clearly, for anybody who's a fan of that sport, and it was selling something related to that sport, it was obvious what it was. And so we did this exact same analysis, because you can't just assume that you're going to have a slam dunk just because somebody is famous. And it gets harder the more divorced you get from their actual name and image. And so you do have to very carefully parse out what's being used, where is it being used, who's the target audience. For us, it was a bit easier because it was, anybody in the sport where they're selling materials and equipment related to the sport. But had they been selling, I don't know, cookware, it may have been a totally different analysis for us.
Yeah, and one of the critical points I think that we're kind of circling around is that if you're suing under 1125A, you need to make all those showings to establish that there's actually consumer confusion. Whereas under a right of publicity claim, each state who has a right of publicity statute or a common law claim has its own standards that need to be established, but they usually don't orbit around a showing of consumer confusion. Instead, it's a showing of, use, a commercialization of the persona or the personality, without the celebrity or the individual's permission. Yeah.
Before you move on, Paul, the one other thing I wanted to note was your discussion about the copyright defense, the potential copyright defense that was waived, and the fact that the defendant there actually had licensed an image. I think it highlights the importance. I'm sure that everybody on this call and represents very different types of clients. It really highlights the importance of the clearance process.
Yeah.
And just because you own one bundle of rights does not mean that you can use something any way you like. It's important to have a clearance process in place where somebody with a law degree and experience in this space is ensuring that everything has been cleared, not just necessarily like the copyright.
Yeah, and that becomes a hornet's nest if you're trying to use a celebrity's image or identity in the United States for the very reason you mentioned earlier, Amy, which is we have this patchwork of laws with respect to rights of publicity. And you're going to need, if you're undertaking a national campaign, you're going to need someone to assess are there any nuances in any states that, you know, subject us to potential liability. You know, something may be okay in one state, but not okay in another.
Hmm.
Yeah. Okay, well, we'll move on now to the actual sort of the sexy part of the presentation that you all came for, which is discussing, you know, Swift's and McConaughey's applications. Any of you want to kind of go over the applications and I can play them, or do you want me to just kind of give the details? I'm
And
fine
you
with
can
it.
get into the details, but I'm just surprised that three of us are here, and this application was just filed like 6 weeks ago.
I know it's weird how it's like it's a little bit of the Taylor Swift phenomenon that anything she does, I think, just makes waves. Yeah.
All right, take it away, Paul.
Okay, so these applications were filed in April 2026. They're awaiting examination. I'm going to play for you the applications. To be clear, um, these are it's a little bit weird. These are both the specimens of use and the um, and what was submitted as the trademark itself. Although the trademarks themselves are the words in this first one, "Hey, it's Taylor Swift." The spoken words, hey, it's Taylor Swift," and the second one, "Hey, it's Taylor." So I'll go ahead and play the first one.
Hey, it's Taylor Swift, and you can listen to my new album, The Life of a Showgirl, on demand on Amazon Music Unlimited.
Okay, you guys heard that?
Yes.
Yeah, and here's the second one. This is "Hey, it's Taylor," not "Hey, it's Taylor Swift." Um, sorry, here we go.
Hey, it's Taylor. My brand new album, The Life of a Showgirl, is out on October 3rd, and you can click to pre-save it so you can listen to it on Spotify.
By the way, just one thing that jumped out at me when I first encountered this was the demonstrably different register in which she's speaking both of these trademarks. One is much higher. For example, "Hey, it's Taylor Swift,"
Hey, it's Taylor Swift.
versus "Hey, it's Taylor,"
Hey, it's Taylor. My brand new album.
which I think may go a bit to the type of protection she might want from this application as to whether or not she's entitled to it. We'll get there. But here is some of the details for the applications. It's a Class 41 application. The usual sort of goods and, excuse me, services in Class 41 for a person of Taylor's stock, and based on it's a Section 1A application, or there are Section 1A applications. This means she is claiming to have used these marks in commerce since as early as 2011. Um, so let's look at here are the um, registrations owned by Matthew McConaughey. So there's a bucket of registrations, but there's kind of four fundamental registrations. One is a sound of Matthew McConaughey saying, "Just keep living, right? I mean, what else are we gonna do?" And then the sound, "All right, all right, all right," which you may know from the movie Dazed and Confused, which begs the question, does Matthew McConaughey even have the rights to register "all right, all right, all right"? Given that those words, I think, were penned by Richard Linklater. But
I suspect that either he cleared it or it's just not enough to copyright the phrase.
yeah, I think you're right. Um,
And by the way, we have seen the questions are getting fed to us. We were not seeing them as they came in, so we're going to circle back on them in a few minutes after we get through this. So we're not ignoring the questions.
Great. Thank you for that, Amy. So yeah, these are the two word marks, excuse me, not word marks, sound marks. And then he also filed, or his company filed, these motion marks. Now, they're kind of one and the same, as I'll show you in the YouTube videos coming up, the specimens. The one on the left, that image is of him saying, "Just keep living." And the one on the right is him saying, "All right, all right, all right." But he does not claim in these particular registrations the sound. He only claims the motions. So in the first set of registrations I showed you, these are the sounds that Mr. McConaughey is uttering. And the second set, it's the images of him uttering them, but it's not actually the utterances themselves. So again, to put a finer point on it, the first set is for his voice, the second set is for his image. So here's what he submitted to the trademark office as his specimens of use, and these were accepted as acceptable specimens of use and um, resulted in the issuance of registrations. Before I play it, basically what these are like YouTube videos he's put up with him just kind of like doing spontaneous poetry bits. And then I'll skip to the end, and that's where the videos and the sound marks are used. And they're used at the end, I guess, sort of as kind of these trademarks at the end of these videos. You can kind of see what they're trying to do here.
What's up? Friday's here. Time to unwind, tune in, and find your kind. So I got 5 minutes of McConaughey coming at you.
Okay, so we don't need to watch all of Matthew McConaughey doing that for a minute, but it's him just, waxing poetic at the viewer. And then we'll get to the end here.
Find our frequency. Just keep living.
Just keep living, right? I mean, what else are we gonna do?
So you see he's appended that to the end as like a brand indicator of sorts. Same thing here. This is January 3rd, F off gravity, which I encourage you to listen to on your own time.
How are we gonna do it if you really don't want to dance by standing on the wall?
Okay, so that's him. Okay, so you get to the end here. So again, same idea. It's him at the end of this video, just appending this video of him saying, all right, all right, all right, as if it's an indicator of source. And maybe it is an indicator of source. Oh, how do I go to the next page? Okay, and then he also filed this application recently of a headshot, more or less, of him. I mean, this has got to be the most attractive trademark application of all time. Wow, look at that guy. So there he is. And he submitted, by the way, a specimen of use. This is a 1A application that just shows little like thumbnail clips of this image used throughout like his website. So ostensibly, the thumbnail use of this image throughout his website, he claims operates as a trademark. So yeah, the Swift applications, the McConaughey registrations. You can register a sound or a video. Yes, you can. You can register a sound. I mean, how many of us identify this as an indicator of source? Bum, bum, bum. It's NBC, Or people of my vintage playing video games, you might recognize like, it's in the game, or Sega as video game sound marks. But what do you guys think, Amy and Irene? Do you think these marks function as indicators of source?
Well, I think the trademark office thought so. I don't know. The one about his face, I think, is the photograph is an interesting one. We'll see where that kind of takes him with the PTO. Before we get into their particular applications, I did want to circle up on some of the questions from the case that you litigated, the Bob Marley case, Paul.
Sure.
There was a question about would a disclaimer have been sufficient? And there was another question about Rogers and versus Grimaldi. First of all, the Rogers test is the First Amendment defense that is available for anybody asserting that this is a creative work. Therefore, there's no Lanham Act analysis at all, and a totally different test applies because we have to defer at some point to First Amendment rights. A few years ago, the Supreme Court in a case called Jack Daniels, it's a case, it's now shorthand as the Jack Daniels case, but it's about the Bad Spaniels dog toys. And there was a big fight over whether or not Bad Spaniels infringed upon Jack Daniels' marks. And the Supreme Court rolled back Rogers versus Grimaldi, which was previously had been broadened over the years since it was first decided. in the Second Circuit. It had been widely adopted. Now, in order to successfully invoke the First Amendment and avoid the entire Lanham Act likelihood of confusion analysis, you have to show that the defendant is using the mark as a mark, which means using it as a source identifier. And so in those situations, if they're using the mark as a mark, then you can get out of the Rogers test.
Right.
But it's where that line is.
Yeah.
Just for the
Yeah.
case.
So Amy, on that, I appreciate you remembering so much from the case, because it was interesting to see that case was a case filed by the infringer for declaratory judgment. And they would file their complaint. They said, we have this trademark. And the Supreme Court actually cited their own complaint, saying they conceded and they admitted unequivocally that this is their trademark. So I think they gave a gift in a way to Jack Daniels and made things a little bit easier for the Supreme Court to come down. So that one, I just want to add to that. But yeah, I think we're still seeing the impact of the Supreme Court's decision that came down 2 years ago.
That's exactly right. I've got a case now on appeal where the scope and viability of the continued existence of the Rogers test will be at issue. And so I'm not going to discuss the particular facts of the case, but it will continue being litigated. And I predict that some people are thinking that the Supreme Court wants to roll back Rogers even further. And so the question is, how much further will they roll it back in order to, but what that means is for creative works, films, books, whatever, can you have a title of something that has a mark that somebody else uses? Can you have a fictional product in your show that may just happen to have the same name as some real product? Who knows? TBD. The disclaimer question, can you just like put a disclaimer on something? Probably not.
No.
Right?
Yeah.
No. Like you can't. Here's the thing though. You might. So in our case, ours is a creative work. We represent the studios and show creators. And at the end of the show, there is a disclaimer that says any similarity between anything in this show is totally coincidence. Everything here is a work of fiction. That disclaimer actually was cited by the district court in granting our motion to dismiss, because there we were asserting a First Amendment defense and there's absolutely no likelihood of confusion. So because there's a disclaimer that was relevant to the likelihood of confusion analysis, even though she never even got to the likelihood of confusion analysis, it was still relevant to the inquiry that there's already a disclaimer. Now, if you're doing it in the facts that Paul has, I don't think it would be remotely sufficient to say, hey, I'm selling this cookware and I've created a generative AI version of Taylor Swift selling my cookware, but here's the disclaimer, that's not really her and she doesn't really endorse this. That's not going to get you anywhere.
Yeah, I think that's exactly right. And you anticipated what I was thinking, Amy, with respect to, I think a disclaimer could be of some value in something that's really like a creative work that is using, for purposes of what we're discussing today, AI generated images of a celebrity, but it's something that's ultimately an endorsement or a commercial in nature. I don't think a disclaimer is going to do anything. In fact, sometimes disclaimers, to the extent they identify the celebrity by name, just are another way to get SEO clicks to the product,
Exactly. Some clients, they would rather not have a disclaimer. Sometimes we are now entering into some kind of settlement agreement, and the infringer or accused infringer is saying, why don't I just put a disclaimer going forward? Most time the mark holders or copyright holders or IP holders will say, we rather not, because it will draw more attention and draw more clicks.
Yeah.
So getting back to the applications, somebody else had raised, why are we talking only about NIL? That's just shorthand, right? The whole bundle of rights that we're talking about is name, likeness, photograph, portrait, voice, signature, personality, persona. So it's all of the the bundle of attributes that may or may not be protectable under traditional right of publicity law. And that varies widely, right? Like some of it's statutory, some of it's common law. In New York, you might not be able to protect a signature, but in California, you can. So all of that now is sort of wrapped up in what can you also protect under the Lanham Act. And so here we're seeing that you can definitely protect your voice or a phrase. I don't know that you can protect the sound of your voice. Maybe you can under the Lanham Act. You certainly can under right of publicity law as long as it's distinctive enough. But her phrase is what she's protecting in combination with her voice. Now, I think if somebody asked, what if my daughter says, "Hey, it's Taylor," I think she can probably do that without being sued by Taylor Swift for a number of probably just
Well, I mean,
practical reasons, but if you're named Taylor, you're going to have a First Amendment defense. But in general, Taylor Swift can protect her saying, "Hey, it's Taylor," because that's used in conjunction with her selling her music.
well, let me ask a question. So Taylor Swift, presumably, and I would bet my savings on it, owns a registration of Taylor Swift, just her name.
She does.
Yes,
I haven't checked, but I'm sure she does.
Yeah, for the services that are issued in this application.
Yes.
So my question, what is she getting through this application that's not already covered by a registration of Taylor Swift alone for those services? It doesn't, to me, like I'm wondering, and I think maybe the application is meant to hint at some weakness in the current, statutory landscape for celebrity endorsements when it comes to Gen AI, because I think Taylor Swift's existing registration of Taylor Swift alone, the word mark, could be leveraged in the same way that her current application is going to be leveraged. But maybe I'm missing something.
I mean, maybe, but I think the registration of anything pertaining to anything that's also covered by right of publicity gets you a few different benefits as the rights holder, the plaintiff, the putative plaintiff. It's a ticket into federal court. And so that can be extremely valuable depending on the jurisdiction. I know that at least in Los Angeles, most practitioners here will know that federal court moves astronomically faster than state court. There's just different resources. There's a uniformity of law that you don't need to worry about. There's potential for getting protections using the registration number, like an automated service that'll fire off cease and desist letters for you. And then there's the remedies, right? You have set remedies under the Lanham Act. Remedies under right of publicity law are going to be a patchwork, and you have to figure out what's what. So there are certainly benefits to registration. There's also, I think, weaknesses that come with it, because you are always going to have to, if you don't have a registration, you have to prove secondary meaning. And you're still going to have to prove likelihood of confusion. And you're going to have to be concerned about how something is being used. Is it being used as a source identifier? Like, it's not clear to me that that this would cover certain uses that only right of publicity could cover. So I think what Taylor Swift is doing, what Matthew McConaughey is doing, is they're making sure that they have all the arrows in their quiver that they possibly have. Because right now there's no like single arrow that they could own that would protect everything. They're just making sure that they have everything.
Right. You can only imagine the conversations they were having as the deep fake is all over, dealing with it every day. So the legal team, management, the celebrity got together and said, okay, what else can we do? Copyright is not there. Federal right of publicity is not going to happen for another, who knows how many years. I think we're in the third or fourth version now, so we can talk about that a little bit later. And everybody's kind of looking at the Lanham Act and it's like, can we do something under Section 43? So I think it's very clever that they came up with this. But when I deal with some of the clients who are kind of dealing with the similar situations, I want to make it abundantly clear that they understand the limited scope of each registration. And unlike copyright or right of publicity, trademark, service mark has to be tied to a specific goods and services. And unless you use it for that particular goods and services that you're registering for or apply for, you may eventually lose that right. But going back to that, that was a very interesting question coming from a father or mother of a daughter whose name is Taylor. Yes, Amy is correct, 100%. There are so many different ways to make sure that your daughter is free to say, I'm Taylor. But if your daughter is going to file a new application for Taylor something, you have to think about whether that is going to be refused. That application may face refusal based upon Taylor Swift registration, or if it's the voice that is similar, is that going to face a potential refusal on that ground? So as you kind of navigate through all this deep fake and Gen AI issues, having your identity, whether it's your voice or image or the name itself, it is one way to ensure and creating another maybe sharper arrow. I think just purely from the IP protection point of view, I looked at it. If you have a means to do it, great. The application filing fee alone is $350. If you adopt the pre-designated descriptions, if you're going to come up with your customized description, that's additional $200. And those things add up really fast. So if you're an influencer, you just have some, clicks on Instagram and your YouTube channel is picking up. Sometimes it's really hard for a practitioner to recommend that you go this path.
Yeah, and I think it bears repeating, and Irene, you alluded to this, is the narrow protection of these sorts of trademarks. If you're an influencer and you register your voice saying your name, hi, I'm Paul Bost, your registration is not going to be for your voice uttering all words. It is limited to your voice uttering those words. Now, as to whether or not you'll be able to establish that other uses of your voice, uttering similar phrases or other phrases is confusingly similar, maybe you'll be able to establish that. But it should bear repeating that if Taylor Swift's applications are granted, she's not obtaining a registration in her voice, writ large. Nor is Matthew McConaughey, nor does he have a registration of anyone saying the word all right, all right, all right, or the words. It's him saying it. They are narrow protections.
That's right. But one other benefit of registration, well, there's two. If you represent celebrities who have endorsement deals with like exclusive endorsement deals, Lanham Act actually provides for, and I don't know if registration really matters, but it's a fact worth knowing. The Lanham Act provides for standing for the exclusive licensees. So if you have a celebrity who may not want to get involved and may not want to go through the hassle of filing a lawsuit, but you're the exclusive rights holder to that endorsement, you can still assert the rights for the, implied, endorsement.
Yeah.
Why am I blanking on the name? The violation of the right of endorsement. So that, though, it's a little bit less clear whether you could, as an exclusive licensee, do that under the right of publicity laws, because it's a benefit. Another benefit of the Lanham Act is the remedies that may not, like in California, they're pretty much similar. They both have statutory or California statutory damages, but if you're a celebrity, you're not going to go after those. Both have actual damages, profits, treble damages versus punitive in California and attorney's fees. But like in New York, there isn't any attorney's fees provision. And so Lanham Act is going to potentially open the door to a lot more remedies that you wouldn't have depending on what state you're in. In terms of like, how is all of this applicable to generative AI? The existing framework was already applicable to Gen AI. Just the Vanna White case, the Cheers case, all of that wasn't a straight up, oh, we took a picture of Vanna White. It was a robot. And so
Yeah.
concepts that were already being litigated under right of publicity and Lanham Act, they already existed and they're just being applied now to generative AI. The difference is with the advent of generative AI, it's democratized the ability to create the robot, to create, the norm from Cheers, whereas before only somebody with enough money and resources to create that could do it. And it didn't happen as often. But now everybody can go on and like create whatever they want using any number of platforms. And so it has brought all of these issues front and center because now we have more people using software to create voice-alikes or lookalikes or whatever. And all of these issues that were already percolating, they just didn't come up that often. They're now front and center.
Yeah, and I think that's exactly right. And I think one reason these applications and registrations or these applications might have been filed is to hint at how the current laws or the registration regime doesn't suffice to provide protection against, the democratization of these technologies. There's such a glut of content now. We need new law to protect our rights. And we'll do what we can by filing these applications that are unusual, but these are because they're another arrow in our quiver, but they are ultimately not going to get us as celebrities and celebrities' rights holders where we want to be with respect to policing unauthorized images of ourselves. Let me go to we kind of got into this a little bit
Right.
already,
Maybe
but
already touch upon most of it, but this is coming directly from the United States Patent and Trademark Office, and it just identifies 6 different benefits. And one of the things that I value from the expansion of trademark rights or brand protection globally is being able to use a US registration as a base to go to other countries. So whether you're filing a WIPO application or you're using the US application as the base to file in other countries, and as long as you file within 6 months, you can actually claim priority based upon the US application. So there is definitely benefits there. And then Amy already touched upon giving public notice, and anybody searching the USPTO, they'll be able to see that. And then obviously having access to federal court, there's a tremendous benefit there. We do have some folks importing things from different parts of the world, and being able to record your registration with the US Customs and Border Protection, that's been tremendously helpful. That's where your tax money actually goes to work. So for various reasons, I think there is a reason other than preventing somebody hijacking your name, getting a registration.
and
Oh, and then, so this is
Yeah.
this morning as I was trying to see if I can do a takedown of a trademark. So this is coming directly from YouTube. And if you see, something that you want to take down, you go to the YouTube trademark complaint, you fill out the form, and then you get to the place, if you go to the next page where you enter your name and you now have to identify or specify whether your mark that you're asserting or you own is registered. I click no, I claim use rights, common law rights, but it still asks me to enter a registration number. So it's like shaming me for not having a registration. Either now I have to say NA or deal with this box, because in their mind, it's so much easier if you have a registration. But if you take me to the next slide, this is a kicker where it says, please provide images or documents from your country's trademark office as proof of your ownership of the mark in question. So if you have a piece of paper from the USPTO, copyright registration certificate, you just have to upload it. You don't have to prove ownership, presumption of validity is there, enforceability is there. But now if you're relying upon your common law rights, you have to upload quite a bit to prove that you own the rights and your trademark is valid or your image is valid. So I think additional reasons for having your image, likeness, voice register.
And this, I'm really glad you brought this up, Irene, because this poses an interesting question, which is imagine there's a Gen AI video of Matthew McConaughey where he does not use the words all right, all right, all right, or just keep living, but it's him, the Gen AI version of him, just addressing the camera. Can you assert your registration of your Matthew McConaughey motion mark to have it taken down? And presumably you're not Matthew McConaughey is not going to be able to make a copyright claim, just unless he for some reason had the Gen AI was made from copyrightable assets that Matthew McConaughey owns, which seems unlikely. Can Matthew McConaughey leverage this motion mark to remove a Gen AI version of himself? And I think
Exactly. The keyword here is leverage. Even though it may
Yeah.
not be identical, I think you can leverage.
Yeah.
So this is directly from your case, 56 Hope. And I thought it was interesting because this case came down more than 10 years ago. At the time, most of our clients were not dealing with the deep fake as much as we do with now. And then, yes, this is the language that you cited, both of you, where it says, we reject defendant's contention that the application of those principles result in a federal right of publicity, as if it was a bad thing. I mean, from my point of view, I would like to see a more consolidated, more consistent right of publicity that we can point to. Trade Secrets did it. Hopefully we can get there. So I just added this slide this morning.
Yeah. So speaking of which,
yes,
I don't know if Amy, you want to address this.
The no fakes. This has been percolating. So this whole conversation that we're having about the weaknesses in the right of publicity law, the patchwork, all of the confusion and transactions costs that it results in, coupled with generative AI, resulted in congressional inaction, I suppose. This act has been kicking around Congress, I think now for at least a few years. It's called the No Fakes Act. There's been several different variations of it. There were other competing acts. It finally, maybe like last few weeks, it does appear to have gotten some traction again. Now, in May of 26, there's a revised bipartisan version of the No Fakes Act. And this one actually has the backing of both Gen AI and tech companies. OpenAI and Google are on board. SAG-AFTRA is on board. And it would create a federal right for every American, not just celebrities, to control their voice and visual likeness in digital replicas. And it creates liability potentially for both creators of unauthorized replicas and platforms who facilitate that with actual knowledge. And it explicitly states that adding a disclaimer label is not permitted as a valid defense. It excludes certain digital replicas for First Amendment reasons. It does create a notice and takedown provision very similar to what we see in the DMCA, which that currently does not exist. For like, if anybody has rights being violated, try getting those taken down off of YouTube without having a copyright claim. It's very difficult because it's just a feasibility, administrative issue for the platforms. They just don't have it built out. Because of DMCA, they do have that built out, and this would create a parallel type of takedown provision. And it preempts largely state laws to create a workable national standard. I haven't looked at the particular bill to see if it's total preemption. That would be really interesting because the prior No Fakes Act was only like an overlay. So you could have a federal claim, but it was in conjunction with the existing state laws. If this is total preemption, that would be an interesting and very massive change in the law. So if passed, it would be structured to take effect 180 days out. I don't know. I haven't seen if there's like a betting pool on it. I'm betting that it doesn't happen this year, but maybe I'm wrong.
Do you know, Amy, if there's any sort of registration component or register associated with the No Fakes Act where you can?
I'd be very surprised if there's not, because otherwise, how could you have a takedown provision but I don't know the answer for certain. I would be surprised if there's not some sort of a registration component.
Yeah.
I think that's the one that the Beverly Hills Bar Association should take on as a next panel.
Yeah.
With that, David, I think we are 2 minutes past.
Yeah, I think we're at the top of the hour. Well, look, thank you everyone for such an interesting and thoughtful conversation about obviously a very sophisticated and nuanced topic that you've really helped us dig into. Did you have any parting thoughts or anything else to add, or with that, should we be concluded for today?
Just apologies if we didn't get to all of the questions, and thanks to everybody for attending, and also obviously Irene and Paul and David. You guys are all wonderful.
Yeah,
Thank you.
echo all that. Thanks very much.
Well,
Thank you.
thank you to you all for your time and expertise. And with that, we are concluded. Thank you.
Take care.